Constitution, describe briefly the Constitution of the Supreme Court of India. What are the qualifications for the appointment of a judge? What is their tenure of office? How they can be removed? In a democratic setup, the state has three distinct but ordinate units. Coordinate units: the legislature, which makes the law; the executive, which executes the law; and the judiciary, which interprets the law. Legislature, which makes the law; executive, which executes the law; and the judiciary, which interprets the law. There may be disputes incidental to such position between the units and union or between the units themselves. A central Supreme Court is needed to decide such dispute and to interpret the law for guidance of all. Thus, the Supreme Court is the guardian of the Constitution. It the savior of people's right and liberties, the adjudicator between different organs and unit of state. Constitution of Supreme Court, Article of our Constitution provides the Supreme Court of India shall consist of a Chief Justice of India and 30 other judges until the number of judges is increased by Act of Parliament. Appointment of Acting Chief Justice, Article 126. When the office of Chief Justice of India is vacant, or when the Chief Justice is by reason of absence or otherwise unable to perform the duties of his office, the duties of his office shall be performed by any such one of the other judges as the President may appoint for the purpose. Appointment of acting chief justice is mentioned in Article 126. When the office of the CJI is vacant, or when CJI is by reason of absence or otherwise not able to perform the duties of the office, the duties of his office, the duty of CJI office shall be performed by such other judges as the President may appoint for the purpose. Appointment of ad hoc judges, Article 127. If at any time there should be a quorum of the judge of the Supreme Court available to hold or continue any session of the court, the Chief Justice of India may, with the previous consent of the President and after consultation with the Chief Justice of High Court concerned, request in writing the attendance at the sitting of the court as an ad hoc judge for such period as may be necessary, or a judge of a High Court duly qualified for appointment as a judge of the Supreme Court designated by Chief Justice of India. Appointment of ad hoc judge, Article 127. If at any time there should not be a quorum of the judge of the Supreme Court available to hold or continue any session of the court, the Chief Justice of India may, with the previous consent of the President and after consultation with the Chief Justice of the High Court concerned, request in writing the attendance at the sitting of the court as an ad hoc judge for such period as may be necessary, or the judge of the High Court duly qualified for appointment as a judge of the Supreme Court designated by the Chief Justice of India. Attendance of retiring judges at sitting of Supreme Court. Article 128 states that attendance of retired judges. The retired judges can attend at the sitting of the Supreme Court. The Chief Justice of India may at any time, with the previous consent of the President, request any person who has held the office of the judge of the Supreme Court or the Federal Court, or who has held the judge of a High Court, is duly qualified for appointment as the judge of the Supreme Court, to sit and act as a judge of the Supreme Court, and every such person so requested shall so sit, while so sitting and acting, be entitled to such allowances as the President may by order determine, and have all the jurisdiction powers and privileges of, but shall not otherwise be deemed to be a judge of that court, provided that nothing in this article shall be deemed to require any person or aforesaid to sit and act as a judge of that court unless he consents to do so. Change in position after 99th Amendment of the Constitution. The Constitution 99th Amendment Act 2014 has also amended Article 127, appointment of ad hoc judge, and 128, attendance of retired judges sitting of Supreme Court, which are related to appointment of ad hoc judges and attendance of retired judges at the sitting of the Supreme Court respectively. Now, according to these amended articles, these appointments may be effected by written request of the National Judicial Appointment Commission. These ad hoc appointment and appointment of the retired judges at the sitting of the Supreme Court may be effected by written request of the National Judicial Appointment Commission, which shall act in this respect on a reference made to it by the Chief Justice of India with the previous consent of the President and after consultation with the Chief Justice of the High Court concerned. Chief Justice of India at present gets a salary of 1 lakh rupees per month. and other judges of the Supreme Court get a salary of 90,000 per month. They will be entitled to pension also. Pension also. Mode of appointment of a judges. How judges are appointed. Position after 99th Amendment. According to a new amendment of the Constitution, 99th Amendment Act 2014 received the assent of the President on 31st December 2014. In Article 124, Clause 2, every judge of the Supreme Court shall be appointed by President on the recommendation of the National Judicial Appointment Commission referred to in Article 124A, Article 124, Clause 2. Provision for National Judicial Appointment Commission are provided under new inserted Article 124A by amendment of the Constitution 99th Amendment Act 2014, which is as follows. 124A, then clause 1, there shall be a commission to be known as National Judicial Appointment Commission, okay, consisting of following, namely, the National Judicial Appointment Commission consists of following members. Number A, Chief Justice of India, Chairperson ex officio. Number B, two other senior judges of the Supreme Court next to the Chief Justice of India, members ex officio. Number C, Union Minister in charge of Law and Justice, member ex officio. Number D, two eminent person to be nominated by committee consisting of Prime Minister, Chief Justice of India, and leader of opposition in the House of the People. And where there is no such leader of opposition, then leader of single largest opposition party in the House of the People of members. So two eminent person to be nominated by a committee. The committee would be made up of Prime Minister, CGI, Prime Minister, CGI, or leader of opposition, and where leader of opposition is not there, then leader of single largest opposition party. So these three person will make a committee. PM, CGI, and leader of opposition will make a committee, and that committee will nominate two eminent person. Okay, and that eminent person Union Minister of charge of Law and Justice, member, then two senior judge, Chief Justice of India. These are the four kinds of people. Five peoples are there in National Judicial Appointment Commission. Number 1, CGI. Number 2, senior judge, 2 senior judge of Supreme Court. 7 people हो गए ना, 2 2 4 2 6 6 peoples are there. 1 CGI, 2 senior judge, 1 union minister in charge of law and justice, then 2 eminent person, nominated eminent person by committee, consist of PM, CGI, and leader of opposition. So provided that one of the eminent persons shall be nominated from among the person belonging to SC, ST, and other backward class, minorities, or women. Provided further that an eminent person shall be nominated for a period of 3 years and shall not be eligible for renomination. If one person is nominated, then he shall not be or she shall not be eligible for renomination. Number 2, no act or proceeding of the National Judicial Appointment Committee shall be questioned or be invalidated merely on the ground of the existence of any vacancy or defect in the constitution of the commission. That means appointment cannot be invalidated or cannot be questioned only on the ground that existence of any vacancy or defect in the constitution of the commission. 99th Amendment 2014 unconstitutional and void. The Apex Court in Supreme Court Advocate on Record Association versus Union of India case, AIR 2016 case, SC 117, 2015, AIR SCW 5457, has declared the Constitution's 99th Amendment Act 2014 as unconstitutional and void. Consequently, the Article 124 Clause 2, 127 appointment of ad hoc judge, 128 appointment of retired judge for the sitting of the Supreme Court, and they were prior to this amendment stands revived. Now, according to revived prior Article 124 Clause 2, every judge of the Supreme Court shall be appointed by President by warrant under his hand and seal after consultation with such of the judges of the Supreme Court and of High Court in the state as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65 years. So every judge, Supreme Court judge, how it shall be appointed? Supreme Court judge shall be appointed by President under by warrant under his hand and seal after consult. President will consult with that judge which he likes or which he thinks to be consulted with. He may be a Supreme Court judge or High Court judge in the state or any state. So, by that consultation and through a seal and warrant in his hand, he can appoint any judge as the Supreme Court judge. Every judge of the Supreme Court shall be appointed by President by warrant under his hand and seal after consultation with the such of the judges of the Supreme Court and of the High Court in the state as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65 years. As for appointment of the CGI is concerned, so that's all about the appointment of the judges. If you find it useful, like, share, subscribe my YouTube channel. Thank you for watching my video.